May it please the Court, good afternoon, Your Honour. I am Aarya Berthier, appearing as counsel for the appellant, Mr. Joseph Fizzi. With Your Honour's leave, I'll be speaking for 15 minutes and will be respectfully serving 2 minutes for my rebuttals. Your Honour, the sexual abuse that the respondent has faced at the hands of her father is repugnant, inexcusable, and regrettable. However, it is unfortunate that by the time the respondent had made up her mind to take legal action, the limitation period for personal injury claims had expired. Thus, to counter this, the respondent has then framed her claim as a matter of breach of fiduciary duties between her and her father. This leads us to the underlying issue before the Court today, whether fiduciary relationships can be extended to include parent-child relationships. With that, I have one submission to make. It is submitted that it would be inappropriate to extend fiduciary relationships to include a parent-child relationship. Firstly, as a preliminary point, I should set out the law regarding fiduciary duties in Singapore. In Bristol and West Building Society, it has been stated that a fiduciary relationship arises when someone has undertaken to act for or on behalf of another person, and the distinguishing obligation of a fiduciary relationship is that of single-minded loyalty. In order to determine who is a fiduciary within a relationship, there are 3 categories that have been set out in the High Court case of Deutsche Bank in Singapore. Firstly, by contract, then by established categories, and lastly, on particular factual circumstances. While it is true that the categories of fiduciary relationships are not closed, the High Court in Deutsche Bank has stated that beyond contract and beyond established categories of fiduciary relationships, the Court should be extremely slow to extend this doctrine towards new cases, and it would only be found on exceptional circumstances. Hence, the question for this Court is what exactly constitutes an exceptional circumstance to find a fiduciary relationship. To decide what constitutes an exceptional circumstance, the English, Australian, and Singapore courts have adopted the undertaking approach. In Ng Eng Gee, the Court of Appeal in Singapore has stated that the raison d'etre of fiduciary obligations is that an agent has undertaken to act for or on behalf of the interests of his principals, and he cannot be permitted to act against such principals. And in the Court of Appeal, the case of Susilawati and American Express Bank, it has been stated that the critical feature for these relationships is that a fiduciary has undertaken or agreed to act on or behalf of his principal in the exercise of a power or discretion.
Counsel, doesn't a parent undertake not to commit sexual abuse?
Your Honour, sexual abuse is a heinous crime, and clearly my client has faltered on that ground. However, the commission of sexual abuse, as repugnant as it is not an imposition. It does not warrant the imposition of a fiduciary relationship. The duty not to commit sexual abuse is not elevated to that of a fiduciary duty. The inquiry solely hinges on whether the parent has undertaken to put his child's interest above his own interest at all times, such that he cannot act against such interests. And it is submitted that parents, realistically speaking, cannot forsake their own interests in the name of their children's interests, given the 2 factors that I will now explain. Firstly, the Court should be cognizant of the realities at play in real life that pervade familial settings and make it hard or unmanageable for parents to consistently put their priorities or interests of their child first. And secondly, the duties of parents are, even as the law recognizes, that while parents should act for their children, or act and protect their children, they are not expected to serve or be subservient to their children's interests. And thus, it is stated that the fiduciary obligation does not extend to parent-child relationships.
Counsel, doesn't the welfare principle require parents to act in the best interest of their children?
Your Honour, in deciding the type of custody order, the family courts in Singapore have decided to apply a standard known as the welfare principle, as Your Honour has rightly pointed out. However, as stated in the case of Lim Chit Huat Francis, at paragraph 78, the welfare principle is a universal in its application and only applies to cases or disputes between parents in the custody of their children. And hence, it is only to be regarded by the Court as paramount consideration when it comes to such situations where the child's upbringing is in question. And that is not the case at hand today. Thus, the welfare principle would not be used by this Court as an approach to decide whether fiduciary obligation should be extended to a parent and a child. If I may continue in my submissions, Your Honour.
Good morning, members of the Tribunal. My name is Jerald Tan, and I appear alongside my co-counsel, Ms. Yeoh for the respondent, the Socialist Democratic Republica. I'll be speaking for 10 minutes on the jurisdictional objections, after which My co-counsel, Ms. Yeoh, will be speaking on the merits. Members of the tribunal, the respondent raises its jurisdictional objections before this tribunal today because upon careful examination of the facts, the respondent submits that the tribunal will discover that there has been a certain impropriety on the part of the claimant in the procurement of licenses necessary to operate its Republican facility. Thus, it falls upon this tribunal to find that it should not hold jurisdiction because doing so would effectively protect a corruptly made investment. In this regard, the respondent brings one submission before this tribunal, that the tribunal does not have jurisdiction over the claims as the investments who do not qualify as covered investments under Article 1A of the BIT. Furthermore, since it is often difficult to establish corruption directly, it is submitted that this tribunal adopts the methodology of connecting the dots adopted by the tribunal in Methanex and USA. This means examining the individual pieces of evidence not in isolation, but in conjunction with one another to produce the most compelling version of events. And in this regard, we raise three key facts for the tribunal's consideration. The first is the major inflows into Dr. Stange's offshore bank accounts timed together with significant permitting decisions related to the claimant's facility. Dr. Stange was the then Deputy Minister in charge of granting the final approval for chemical permits such as those required by the claimant to expand and operate its facility. And since the source of these inflows is not clear on the facts, the tribunal must then go on to consider the second dot, which is the 2018 Supreme Court of Republica ruling on a citizen suit against the claimants, finding that the permits were improperly granted as the chemical facility was, I quote, below standards, surmising also that the permits may well have been obtained through corrupt means. Mr. Arbitrator, the fact that the facility was found to be below standards implies that under the proper circumstances, it would not have been able to obtain the valid licenses to operate. And finally, the third dot, that being the Respondent's Anti-Corruption Authority's indictment of Dr. Stange in 2016 on bribery, fraud, and money laundering charges after a thorough and complex investigation. The investigations revealed, Mr. Arbitrator, that there was a complex and sophisticated web of bank accounts both within Republica and across a number of offshore locations that had clear markers of years of corrupt dealings.
Counsel, was Dr. Stange ever prosecuted? And why should this tribunal find corruption when there has never been a state prosecution?
Mr. Arbitrator, Dr. Stange was never actually prosecuted, though he was indicted by the Respondent's Anti-Corruption Authority. But this tribunal should still be able to find corruption when there's no prosecution because other tribunals have done the same. Especially since, in this case, it concerns a civil proceeding and the finding of corruption here pertains to a civil proceeding as opposed to establishing some sort of criminal liability for a criminal prosecution. And thus, this tribunal should accordingly still find corruption in this case, despite the fact that there was no actual prosecution. Mr. Arbitrator, employing the methodology of connecting the dots, we submit that a clear and compelling version of events can be formed. It is that during the process of license procurement in 2012, the claimant had corruptly influenced Dr. Stange to bribery. This is evident through the major inflows into Dr. Stange's offshore bank accounts tied together with the granting of permits necessary for the operation of the claimant's facility. The purpose of this bribery, Mr. Arbitrator, is to ensure the continued operation of the claimant's facility, even though it was below standards. The bribery was facilitated and actively concealed from discovery through a sophisticated web of bank accounts linked to Dr. Stange, who has previously conducted years of corrupt dealings. Thus, the tribunal can conclude with reasonable certainty that the claimant had corruptly procured the licenses necessary to operate the facility. And given this finding of corruption, the respondent submits that the tribunal should simply find that the investment had breached its legality requirement and is therefore excluded from protection as an investment under the BIT. Consequently, the tribunal has no jurisdiction over the claims brought before it today. And unless I may be of any further assistance, I hereby conclude my submissions.
May it please the Tribunal, my name is Yeoh and I appear on behalf of the respondent, the Socialist Democratic Republican. I will be addressing the merits for 10 minutes. Members of the Tribunal, the relationship between the claimant and the respondent used to be a firm partnership. However, when the respondent decided to increase the protection afforded to its environment, the claimant took offense. Then, when the claimant's pollution and corruption were brought to light in the 2018 Supreme Court judgment, the claimant objected to being held accountable. And now, members of the tribunal, the claimant goes so far so as to allege breaches of the BIT. The question before this tribunal today is, should the respondent be punished for simply fulfilling its duty as a state? The answer must be a resounding no. And to that, I have one submission to make, that the respondent has not violated its obligation of fair and equitable treatment, short FET for short, under Article 11 of the BIT. I'll now proceed with my submissions. Before I begin, I would like to address the contention my learned friend made regarding the standard under the FET obligation. My learned friend contended that it is the test of whether the claimant's legitimate expectations have been violated. The respondent submits that the doctrine of legitimate expectations has no part to play in this dispute. When we turn this tribunal's attention to Article 11 of the BIT, you will see that Article 11 says that for greater certainty, the standard of FET includes the obligation not to deny justice and to act in accordance with due process. We submit that the phrase for greater certainty indicates the drafter's intention to narrow down the applicable standards to only the most egregious of breaches.
But Counsel, Article 11 also says includes. So why can't FET also include legitimate expectations?
Mr. Arbitrator, we note your concerns. However, even the phrase includes would require any other standard to be as high as that of a denial of justice or a breach of due process. It is submitted that the doctrine of legitimate expectations imposes far too low a threshold for this to be comparable with a denial of justice. And thus, turning to my submissions proper, it is submitted that both the promulgation of the 2017 regulations and the 2018 Supreme Court judgment were within the limits of the FET obligation. The claimant contends that the promulgation of the regulations was not within the limits of due process simply because draft regulations were not published. With respect, this submission is baseless. Not only did the respondent solicit over 1,000 comments from the public, including the claimant, over a period of 1.5 years, it also provided the claimant and other investors in this industry almost 1.5 months to implement the required measures to comply with the new regulations. Moreover, we note that at international law, there is simply no obligation for states to publish draft legislation. As such, the claimant's contentions on this point must be dismissed. Turning now to the 2018 Supreme Court judgment, we submit that the trial that led to the judgment was also within the limits of due process. The claimant raises two complaints: that because the identity of the witnesses were kept anonymous and that they were exempt from cross-examination, the trial was in breach of due process. We submit that given the unique circumstances in which this trial occurred, that both measures were amply justified. Turning to the anonymity of the witnesses, we submit that in a corruption trial, the sensitive nature of giving testimony would have justified the witnesses being anonymous. Mr. Arbitrator.
But Counsel, wouldn't hiding their identities impair the fairness of the trial?
Mr. Arbitrator, we note your concern, but the identity of the witnesses was in fact revealed to the court. It was only kept from the general public, including the claimant. Moreover, we note that in the context of a corruption trial, these witnesses were high-ranking officials of the recently indicted Minister Dr. Stange. As such, being examined in court would require these officials to turn on each other and make allegations that may potentially have criminal consequences. Moreover, given the public outcry that was sparked by Dr. Stange's indictment, with a wave of protests being reported outside the claimant's facility and the Ministry of Environment, these officials had reasonable grounds to fear for their safety, and thus an anonymity order was well justified. Now, Mr. Arbitrator, turning to the exemption of these witnesses from cross-examination, the respondent submits that this measure was also justified and within the limits of due process. The purpose of letting witnesses give testimony and to allow for cross-examination is to enable the court to test the veracity of the testimony, and thus allow the court to make a sounder finding as to the facts. We submit that this purpose was indeed fulfilled despite the lack of cross-examination. We may note, Mr. Arbitrator, that cross-examination is not a requirement of due process at international law, given that cross-examination is unique to common law jurisdictions. We submit that at the corruption trial, the judges played a far more inquisitorial role in questioning these witnesses, and given that the claimant was able to listen to this testimony and submit witness statements in response, we submit that the veracity of the evidence given by these witnesses was sufficiently tested, and the fairness of the trial was not impaired. Unless this tribunal has further questions, I will now move to conclude my submissions. Members of the tribunal, the claimant is an investor that has flouted the laws of Republica and now seeks to get away from it. We seek this tribunal's recognition that an investor cannot have its cake, eat it, and throw it in the respondent's face. Thus, we urge the tribunal to find that there has not been a violation of the FET standard. Unless there be further questions, I end my submissions.